Welcome to Sakshi TV special immigration talk show with attorney Ms. Prashanthi Reddy. Please note that Sakshi TV now has 3 immigration shows every week. On Wednesdays with Prashanthi Reddy in English, on Thursdays with Chand Parvatneni, and on Fridays with Pano Nindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 8667257441. Before we begin the show, please note that the information provided on this show is not legal advice and for general informational purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need any specific legal advice, you can definitely contact the attorney directly. Ms. Reddy needs no introduction, but if you need consultation, you can definitely log on to her firm, which is www.reddyesq.com. Without any further delay, let's welcome Ms. Prashanthi Reddy Garu on our show. Ms. Reddy, welcome back. Andy, how are you?
I'm good, Shivani. Hope you're well.
Yeah, I'm doing well. Thank you so much for asking, Ms. Reddy. So, Ms. Reddy, today we thought we will talk a little about the H-1B layoffs and, get some updates. But before we get onto it, are there any recent immigration updates that we have to know?
Yes, I thought actually yesterday there was an update with reference to the H-1B visa revalidation. So the H-1B visa revalidation, for those of you who don't know, in the past, 2004, in the year 2004 and earlier, if you had a visa in your passport and you needed to extend it, then they would allow you to apply for a new visa without leaving the country. So all you have to do is send your passport to the Department of State, and they would stamp the new visa in the passport and then mail it back to you, within the country. So you didn't have to leave and go to the consulate. So they might bring that practice back in, the visa revalidation practice, and they are likely to publish some regulations to this effect in December, so that's next month, and hopefully we will see that process starting in January. They will start off as a pilot program, which means that they will process 20,000 applications to start off with, and once they see how that goes, then they will open up, I'm presuming, the visa revalidation process to all the other applicants who qualify. So this is a big step that the consulate is taking because of all the visa delays, and especially in some countries such as India, where the visa delays are even more so. To get an appointment is taking several months, and this is outside of their processing time. They would want to have people be able to get a visa appointment at least within 60 days. They are not able to do that presently, and in addition to that, the Dropbox system, that is the system whereby you can drop your application in the mail and not have to go for an interview. So the interview waiver process, which is available for extensions, that will go away in December unless it is extended. So this and that combined, and looking at the present processing times as it is, I think this is a very good step on their part to kind of improve the processing time for visas.
Yes. Can we talk more about the H-1B layoffs? So what is the situation right now in the US, and are people getting their, are people losing their jobs, and are they getting prone to the layoffs?
Yes, so there's been a recent, another round of layoffs by a lot of big organizations. I believe 200,000 people have been laid off. And this is in addition to a splurge of layoffs that took place in the summer. So this is the second big round of layoffs that we've seen in the US. This has especially affected the IT sector and has therefore affected people who are on a H-1B. And so it's important to know what you can do and what you cannot do if you get laid off. So I thought this would be a good time to talk about H-1B layoffs and what the law is.
Yes. So Ms. Reddy, are you talking something?
Yeah, no. So
Yeah.
I can just continue, Shivani. Then what the present law is basically that, previously when a H-1B visa holder lost their job, they were not permitted to stay back in the country. They had to leave immediately. Even one day without a job was 1 day out of status. So that didn't give them time to, take care of their affairs, buy a ticket, close, give up their house or close their bank accounts. So it made sense to have some kind of cushion between the time that they are laid off or they decide to leave the job and then the time that they have to leave the country. So as of January 17, 2017, USCIS started allowing a 60-day grace period after the termination of employment. Now, employment can be either terminated by the employer or the beneficiary or the employee can also decide to leave the job. So either way, they get a 60 days grace period to either file another H1, that is a H1 transfer, or to leave the country, or to change status to some other status, an F1 or a B2 or H4, whatever it might be. Now, there are a lot of issues faced, problems faced upon termination of employment. One problem is that the law requires employers to terminate the H-1B petition. They have to write to USCIS and terminate the H-1B petition. That immediately puts the beneficiary or the employee, makes them out of status. And they then start accruing something called unlawful presence. So if they accrue 6 months of unlawful presence or more, then they're barred for a period of 3 to 10 years, which means that they cannot come back into the country if they leave. So that's the unlawful presence law, which is a separate law. With this 60 days grace period, the unlawful presence clock only starts ticking once the 60 days grace period is over. So during the 60 days grace period, there's no unlawful presence. But after that is over, they start accruing unlawful presence. And then if it's more than 6 months, then they'll be barred for 3 years. And then 1 year, they're barred for 10 years. So something to keep in mind, when you're allowing yourself to stay in the country after your status is expired. Also, unemployment benefits. Most employees, if they get laid off, get unemployment benefits because they're paying for that. It's a benefit that you get because part of your salary goes into, unemployment. The employers' taxes that they pay goes into unemployment. So it's an earned benefit. But unfortunately for H-1B employees, it may not work out that way. They may not get unemployment benefits during that time, because the Department of Labor requires them to be available to work. And the H-1B visa is such that you cannot work until the H-1B is actually filed by the employer. So they cannot work for any employer. So some states then will not allow them to take unemployment benefits because of this fact. So again, another thing to keep in mind. However, when you file a H1, if you do get a job during the 60 days grace and you file a H1B transfer to another employer, you can work as soon as your H1B is received by USCIS. You don't have to wait for the approval. So that kind of helps a little bit with your financial situation, as you don't have to wait for the approval to come in order to start working. You can start working immediately. That's another thing to keep in mind. As I was saying, employers are required to terminate the employment and to withdraw the H1 once the person is laid off by law. They're also required to pay the reasonable costs of transportation of the H-1B worker to their last place of foreign residence. So if the person is from India, then they're required to give them a return ticket to India, to go back to their home country. But this requirement is not for family members. They don't have to pay for return transportation to family members, only for their employee. If you find yourself in the 60 days grace period and you're not able to find a job, you can use EAD if you have, for say, you have a 485 pending and you have an EAD and you're using your H1B, you can decide to use your EAD at that point of time and then remain in the country. But if the employer that's terminated you is the same employer that's filed your green card, then obviously you have an issue. You'd have to do AC-21 to transfer your green card to a new employer, as you know, there has to be to avoid gaps in employment for the green card purposes. And also, if the I-140 is not approved, you might encounter additional complications because obviously if that employer is withdrawing the H1, they will withdraw the I-140 application, which will then lead you to a denial of the 485 and therefore no EAD. So this always doesn't work, but in some instances it might. But it's good to know that you have that backup in certain limited circumstances. So in that 60 days grace period, other than moving to an EAD, you can also file a change of status to an F1. To a student, if you wish to go back to school, this only makes sense if you actually want to go back to school. And it is possible to continue working while in school by taking a CPT. But this again depends on the school, whether they can justify and allow a day one CPT. But the good news is, since there's premium processing available now for a change of status to an F1, this application can get approved quite quickly. And if the college, the school that you're going to has classes that you can attend immediately, it's possible to then get into an F1 status quickly. Of course, the disadvantage is you have to pay the tuition fee. You have to go back to being a student, so that's not easy for a lot of people. To avoid that, now I've noticed that people are, instead of filing change of status to an F1, they are filing a change of status to a B2. This allows them some flexibility to remain in the country. This is a visitor's visa, and this can be filed online. So while it allows you some flexibility to remain in the country after the 60 days grace period, there are complications with this also. One of the biggest complication being that the processing time for a B2 is quite long. So I must say that recently a B2 application was processed quite quickly, within a few months. It generally takes 10 to 12 months to process the B2 application. And a B2 can be requested only for 6 months at a time. So by the time you get the approval, it's useless. So within that 6-month time frame, you'll have to then either file an extension of your B2 for another 6 months, or a change of status to another status such as F1 or H4, or you can, if you get a job, file a change of status from a B2 to a H1. But you'll be only able to do this based on the receipt, because you can't wait for the approval. So based on the receipt, you have to file. Based on a pending status, you have to file for a change of status. And when you do this, sometimes the USCIS might not approve the change of status. They might send an RFE asking for the actual approval, and since you do not have, if you get the approval by that time, that's great, and if you don't, they may not approve the change of status even though they're supposed to, because there is such a law called a bridging law, under which the B2 should only be approvable when filed, but doesn't have to be actually approved. But they're not following their own laws sometimes, so they send out RFEs and then they might deny the change of status portion of the H1B approval. And when this happens, then you'll have to leave the country. You will get a H1B approval, but without an I-94. So you have to leave, and then you can come back on that H1B approval if you already have a visa in your passport. Otherwise, you'll have to go to the consulate for a visa. You can also change to, as I was saying, a dependent status, which is a H4, an L2, depending on what status your spouse is on. Then that's really the best status to be in, because both L2 and H4, some H4s can work. For example, if your spouse has an I-140 approved, you can move to a H4 and get a H4 EAD, and you can start working that way. There might be some gaps in your employment, but eventually you'll be able to start working, depending on how quickly they process your application. So that is quite a good option to change to a dependent status if you're not able to get a job within the 60 days grace period. Now, it's also important to discuss how all these layoffs affect your perm processing. your green card processing. If you're an employer and if you've laid off people, then you have to state it in the application. There's a question in the application, form application, which says, have you ever laid off anyone within the last 6 months within the area of intended employment in that occupation or in a related occupation? So related means that more than 50% or 50% of the job should be the same. That's a related occupation. So if you have, then you have to disclose that in the perm form. And then when you're doing your advertising, you have to interview that person that you laid off. And if they qualify, you have to offer them the job. And if they take the job, after they qualify, you can still continue the perm processing, but you cannot ignore that, those particular applicants who you laid off. Another immediate effect of these layoffs and the market the way it is that you can expect more audits. Whenever the Labor Department sees that there are a lot of jobs available, in this instance, we can presume there are a lot of people available in the market as a lot of people are being laid off. They send out audits. And what happens with these audits is you have to submit everything that you said on the application. You have to submit proof of it. You have to submit the ad. You have to show the applicants. If there are any applicants, you have to do a recruitment report, write a letter submitting all the applicants that applied and if you rejected them or if you hired them. That's called the recruitment report. So all that is done in an audit, and this might lead to a denial if you don't have that proper documentation. In the very least, it leads to an extension of your processing time, because now your labor side processing time can go up, to a year or so. There are other strategies that you can use as an employer, in order to keep your your employees, H1B employees, and in case they lose a job, what you can do is you can use the part-time H1. So you can amend the full-time H1 to a part-time H1, and you can keep them that way. So this way you're paying less salary because they're now part-time, but perhaps you expect to find a full-time job for them in the near future, so you don't want to completely lay them off. So that's one way you can keep them on your payroll. A few things to keep in mind for the part-time H1. There's no minimum number of hours required. So you can file, the number of hours that you require. Full-time is 35 hours. Part-time can be anywhere, even as less as 5 hours. But you have to keep in mind that they have to be able to make at least a living wage from the salary that you offer them. And if they're not able to make that wage, you have to show that they have other means of supporting themselves. So that will, those factors decide how many hours you can put, minimum hours you can put for a H1. And the second point is that you can have a range of hours. It doesn't have to be 15 hours. It can be 15 to 20 hours, for example. And you can pay them that range. So there's some flexibility there, right? Another advantage of part-time H1s is that then you may not be counted towards being a H1B dependent employer, because they only count full-time employees, the number of full-time employees that you have when they look at H1B dependency. So these are a few of the advantages of using the part-time H1 as opposed to the full-time H1. I have a few questions that have been asked of me in the past, and Shivani, unless you have some questions, I can just dive into those FAQs for the remaining time that we have.
I think we still have 10 more minutes, so whatever questions that you've been asked, I think you can definitely talk about it.
So there was a question asked as to what steps can I take before my H1B gets revoked. So you're in the you're not in the 60 days grace period. You are, I guess, in the notice period. So your employer has given you 2 weeks of notice to leave the company. Within that period, or within the period that your employer actually files the withdrawal of the H1, you can presumably file a H1B transfer. and you will have, whatever your latest pay stub is, you will have that. You can file a transfer before the termination actually takes place, and before your H1B approval is actually terminated by USCIS. So there is a small window of opportunity there to file a H1B, so you don't have to use your 60 days grace period. Somebody asked, what is the 10-day grace period? Now, the 10-day grace period is different from the 60-day grace period for H1. The 10-day grace period is automatically given to everyone, and it's added to your I-94. So on your approvals, at the bottom portion, which has I-94, usually has the 10-day grace period, and this allows everyone to have some period of time for you to leave after the expiry of your H1B term, so that you have time to take care of affairs, etc. before you leave. You can also apply for a transfer or an extension in that 10 days grace period time. But so that's what the 10 days grace period time is, and it's always been there. It has nothing to do with the 60 days grace. And it's not something that comes about on a termination. It comes about after the expiry of the H1. Another question is, if your employer has revoked the H1, can he again withdraw that revocation and reinstate the H1? It's very difficult to do. It can be done. You can write a letter to USCIS asking them that you have changed your mind about the withdrawal and they would like to reinstate the H1. But since there's no process in place for this other than writing a letter, might be time consuming for USCIS to do it. They might not respond immediately, and in the meantime, your status is in limbo. So not a great option, but certainly something that you can attempt to do. The next question is, what is the H1B withdrawal process? So how do you withdraw the H1 once you lay off your employee? You simply have to write a letter to USCIS along with the H1B approval stating that you wish to withdraw the H1B approval, and you do not need to give a reason as to why you want to withdraw or why you have terminated the services of the employer. So it's quite a simple process. Another question was, how can I check if my H1B is revoked? So once this withdrawal happens, USCIS withdraws it, and the H1B is then withdrawn or revoked by the employer. Of course, you can ask the employer to notify you once this is done, and employer should get a letter, not always, but most often they get a letter from USCIS confirming that the H1B has been withdrawn. In addition to that, you can also check the status might change on the USCIS website, where you check your status by entering your receipt number. If it's been withdrawn, it will say that on the USCIS website. So that's another way that you can check independent of your employer.
Yes.
So do we have time, Shivani? I've finished this topic, but I can do some more updates.
Yeah, I think you can do some more updates. We still have 5 more minutes.
Okay, great. So I wanted to talk about the recent changes to the PERM forms. This is the green card. We were talking about labor certifications just now. There have been some significant changes to the way labor certifications will now be filed. This is simply because a new system is being used, a new form is in place, and there's a new portal. It's called the flag system, and this is where previously we were filing LCAs in the same flag system. So now they've consolidated it and put the PERM applications in that flag system as well. So legacy system is no longer being used except for responding to existing applications. If you get an audit, you can respond in the legacy system, but otherwise the new system has to be used. The difference in this new system is that a separate account does not have to be created for the attorney by the employer. The employer does not have to answer yes to all the questions before a case can be submitted. In this, the attorney directly has already a username and password or can create one, can apply and submit an application on behalf of the employer, and of course the employer gets an email, and if they want to withdraw the application, they can do so once they receive that email. So there's this change with reference to how the security, if you, for lack of a better word, that is, there in the system. Before it was employer driven, now it's pretty much driven by the attorney. Another change that has taken place is they have linked the prevailing wages automatically to the perm application. So all the information from the prevailing wage, once you put in the case number, gets automatically transferred into the perm application. So this is good and bad. Good because you don't have to enter all that information again, and bad because it won't allow you to enter additional information if you want to. So you can't enter additional job information, you can't enter additional skills information, or any additional information with reference to the work site. There is some information that you can, but very little space for skill set, job description, etc. So because of this, the way we file our perms is now changing. So now we have to file a prevailing wage for each person, has to have a separate prevailing wage with their own skill sets, so that those skill sets can then be transferred to the perm. Before, we would file one prevailing wage for several people who had the same job description and same education, but may not be same skill set. And we would just add the skill sets in the perm application when we filed it, because we could enter all this information manually. Now that we can't, that information has to be in the prevailing wage in order for it to populate. So we're talking about longer processing times, because each application now, you need a prevailing wage.
Understood. I think with that we can end today's session, Ms. Reddy. I think it was very informative, and I'm sure the viewers must have enjoyed it. It's again lovely to have you on our show as usual. Thank you again, Prashanthi Reddy Garu, for tuning in. Thank you for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.
Thank you, Shivani.